1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်984 MESSRS Brothers Appellant vs FAIZAR RAHMAN CHOWDHURY and 3 others Respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Miscellaneous Appeal before ဦးသက်ဖေ Judge MESSRS Brothers Appellant vs FAIZAR RAHMAN CHOWDHURY and 3 others Respondent Insolvency Burma Insolvency Act Section 4(2) placing his claim by a claimant before the Insolvency Court determination of the question whether its decision is final and binding between the parties, whether the claimant can re-agitate the merits of his claim by bringing a regular suit, whether the remedy lies if by way of appeal under Section 75 Burma Insolvency Act grant of leave to appeal, whether the court can exercise in favor of a creditor competency of appeal under Section 4 and 75(3) of the Burma Insolvency Act, avoidance of transfers under Section 53 Burma Insolvency Act, grossly inadequate consideration in the transfer of the house in question, whether the transfer was bona fide transfer on account of pressure of a creditor, absence of collusion and of knowledge of the embarrassing circumstances of the debtor, whether the transfer fraudulent within the meaning of Section 53, hell, when a claimant placed his claim under Section 4 of the Burma Insolvency Act before the Insolvency Court and that court proceed to determine the question, its decision is final and binding between the parties and that it is not open to the claimant to re-agitate the merits of his claim by bringing a regular suit. The remedy by way of appeal is open to the aggrieved party under Section 75 Burma Insolvency Act. Shiv Narayan and another versus Lakshmi Narayan and another EIR 1929 Lahore 761 Mono Mohan Rai Chowdhury vs Bhupe Chandra Rai Chowdhury and others EIR 1934 Calcutta 122-2 Maungbato vs Mapin 12 Rangoon 194 Thainvarai Aki vs ORM PRM Ramanandan Chadia and 1940 RLR page 643 refer to there is nothing in the wording of Section 75(3) of the Burma Insolvency Act restricting the powers of the District Court or of the High Court from giving leave to anyone except the receiver appointed by the court. The grant of leave is a discretionary matter which the court can exercise in favor of a creditor who is undoubtedly a person aggrieved by the decisions of the Insolvency Court Therefore, the appeal is competent both under Section 4 and 75(3) of the Burma Insolvency Act in the matter of the estate of P.A. Mohammed Khani, deceased, 5 Rangoon, page 375, distinguished Kandaswamy, Gooden and others versus Rangaswamy, Gooden and others, AIR 1938, Madras, page 317, refer to. Hell further, the house in question is worth not less than $2,000 in view of the testimony of a witness cited by the insolvent himself. The receiver had in fact reported to the court that the building is worth $6,000. This house has been transferred by the insolvent to his wife, who is entirely dependent upon him in consideration of the foreword of 5 tiers of gold value at $1,000. It is apparent therefrom that the consideration is grossly inadequate. Moreover, the insolvent had since then been living in the same house after the transfer, which would go to show that the transfer was not bona fide, but made with intent to defraud the creditors. A bona fide transfer on account of pressure exerted by a creditor for the satisfaction of his debt in the absence of any suggestion of collusion and without any knowledge of the embarrassing circumstances of the debtor is not fraudulent within the meaning of Section 53, but the transferee and the insolvent were admittedly intimate friends. The transferee knew that many suits were pending against the transferor and that he was in embarrassing circumstances at the relevant time of the transfer. All these factors go to show that the transfer of the tailoring shop was collusive and not in good faith, and it should accordingly be avoided. Official assignee, Madras versus S.M. Sheikh Moeddin, Ruther, AIR 1927, Madras 1013, refer to. Mr. M.A. Subban for the appellant, U. Phatathor for the respondent, Uttaphe Judge, M. Karim Bass. The fourth respondent in this appeal once owned a house in Morley Quarter, Akyep, and a tailoring shop known as the Rangoon Modern Tailoring Shop in FAIZAR Road, Akyep. The appellants sued him and obtained many decrees in civil regular suit numbered 16 of 1952, 13 of 1954, and 3 of 1955 of the Subdivisional Code of Akyep. In execution of the decree in civil regular suit numbered 16 of 1952, the appellants applied for the arrest of M. Karim Bass, who thereupon moved the District Court, Akyep, on 30 January 1956 to adjudge him an insolvent. On 1st October 1956, the District Court duly declared him an insolvent in its insolvency case numbered 1 of 1956. It transpired that the insolvent had transferred his residential house at Morley Quarter to his wife, Madam Saint Alliance, Mat Hazara Khatun, the second respondent, in consideration of the far doward by a deed date the 5th of June 1955, and also his tailoring shop with all stores of textile, sewing, machines, and furniture to FAIZAR RAHMAN, CHOWDHURY, for a consideration of Jet 5,000 by another deed date 15 July 1955. The appellants moved the receiver to apply for annulment of the said transfers, but without success. They therefore moved the insolvency court to have the said transfers annulled under Section 53 and 54 of the Burma Insolvency Act. Subsequently, the appellants found out that the insolvent minor son, Shah Jahan, had purchased a cargo boat for a sum of Jet 15,000 on 17 January 1960. They applied to the Insolvency Code under Section 4 of the Act to direct the receiver to seize the boat on the ground that the vessel had been purchased by the insolvent Binami in the name of his minor son, but their application was resisted by the second respondent as the guardian of the minor on the score that the vessel belonged to the minor inasmuch as it was purchased with the money belonging to his grandmother. The Insolvency Code, after hearing all the evidence, dismissed both the applications of the appellants, who thereupon obtained leave of the Insolvency Code and instituted the present appeal. It has been argued on behalf of the respondents that, so far as the order of the lower court under Section 4 of the Burma Insolvency Act relating to the cargo boat is concerned, no appeal lies to this code, inasmuch as Section 4.2 provides that every such decision shall be final and binding for all purposes as between, on the one hand, the debtor and the debtor estate, and, on the other hand, all claimants against him or it and all persons claiming through or under him. This argument, in my opinion, is misconceived. What this section really means is that when a claimant places his claim before the Insolvency Code and that code proceeds to determine the question, its decision is final and binding between the parties, and that it is not open to the claimant to re-agitate the merits of his claim by bringing a regular suit. The remedy by way of appeal is open to the aggrieved party under Section 75, Burma Insolvency Act, v.d. Ship Narain and another versus Lakshmi Narain and another one. It has also been decided in Mono Mohan Rai Choudhury versus Bhupe Chandra Rai Choudhury and others, too, that the dismissal of the claim under Section 4 really tantamounts to a decision under Section 4 and entitles the appellant to an appeal under Section 75, read with Schedule 1 of the Act. In fact, it has been held by the Privy Council in Mountbatten versus Mapping 3 that under Section 75(2), an appeal lies from an order under Section 4 not only to the High Court but also to the Privy Council. The same view has been expressed in Time Vanai Aki versus ORMP RM, Ramanandan, Tadia, and 1-4. The next submission made on behalf of the respondents is that the appeal against the order of the lower court under Section 53, Burma Insolvency Act is incompetent inasmuch as the lower court can grant leave under Section 75(3) only on the application of the receiver and not on the application of a creditor. According to the Land Council submission, the proper course which the appellants should have adopted was to ask the receiver to apply for leave to appeal, and if he refused to do so, they should appeal to the Insolvency Code under Section 68. In support of this submission, he relied upon the decision in the matter of the estate of P.A. Muhammad Khani, deceased 5, where it was held that if the official assignee refused to move to have the transfers set aside, the creditor relief is by way of appeal to the Insolvency Code under Section 86, Rangoon Insolvency Act, which corresponds to Section 68, Burma Insolvency Act, and not by way of an application for leave to apply to have the transfer set aside. It must at once be pointed out that the said decision has no relevance whatsoever to the present case. In that decision on the official assignee refusing to move the court to avoid the transfer under Section 56, Rangoon Insolvency Act, one of the creditors asked leave to apply for setting aside the transfer, and it was held that the creditor should appeal to the Insolvency Code against the order of the official assignee. Then there is nothing in the wording of Section 75(3) of the Burma Insolvency Act restricting the powers of the District Court of the High Court from giving leave to anyone except the receiver appointed by the court. The grant of leave is a discretionary matter which the court can exercise in favor of a creditor who is undoubtedly a person aggrieved by the decision of the Insolvency Code. In this connection, it will be of interest to refer to the decision in Kandaswamy, Gowden, and others versus Rangaswamy, Gowden, and others said, where it was held that there was any such person aggrieved in Section 75(3) also include a creditor who is aggrieved by an order of the district judge in an application to set aside a seal under Section 53 of the Act made by him upon the refusal of the official receiver to take step. Such a creditor, therefore, may appeal with the leave of the High Court under Section 75(3) without first applying to the official receiver to appeal and getting a refusal from him. I would therefore hold that the present appeal is competent both under Section 4 and 75(3) of the Burma Insolvency Act. Before we go into the merits of the case, it will be necessary to examine the law relating to the avoidance of transfers under Section 53 Burma Insolvency Act in Official Receiver versus PLKMRM CHOWDHURY Fem 7, it has been ruled by the Privy Council that where the receiver is seeking to set aside a mortgage executed within 2 years from the date of the adjudication of the insolvent under Section 53, the owner is upon him to prove that it was not made in good faith and for valuable consideration. The above decision was approved by the Judicial Committee in Pope vs. Official Assignee Rangoon 8. The same considerations were applied to the case of a creditor who asked for an annulment of transfer under Section 53, but the burden of proof in the sense of adducing evidence never remains constant. Once the receiver or the creditor proved that the transfer was made within 2 years of the insolvency and also that it was made either mala fide or without valuable consideration, the transferee is under an obligation to lead rebutting evidence, failing which the transfer will be set aside under Section 53. All that the receiver or the creditor is required to show is that the transfer was made within 2 years and that it was made either not bona fide or without consideration. Thus, in Official Assignee Rangoon vs. Subala Dasi 9, it has been held that under the provisions of Section 55 of the Presidency Towns Insolvency Act, where the official assignee seeks to set aside a transfer made by the insolvent, the onus of proof lies upon him. But if the official assignee proves that the transfer was made within 2 years of the insolvency and also that it was made either not bona fide or without valuable consideration, he is entitled to obtain an order setting aside the transfer in order that a transfer may be excluded from the operation of the session. There are 2 essential elements in the transaction that must be proved. 1. That it was made bona fide and 2. That it was made for valuable consideration. If the official assignee has disproved one of these essential elements, the transfer does not contain both the elements, and therefore the transfer falls to be set aside under Section 55. Reference may also be usefully made to the decision in Ubasai vs. MESSRS 10, where it was observed that in a suit to set aside a fraudulent transfer under Section 53, Provincial Insolvency Act, the burden of proof is upon the official receiver. Such burden of proof can only be discharged by showing circumstances from which strong inference can be drawn that the transfer imputed was made either mala fide or in the absence of valuable consideration, and where the official receiver discharged the prima facie burden which lay upon him, it is for the transferee to explain the case which gives so many and so obvious grounds for suspicion, and show that there was in fact an explanation for the transfer which the court could deem to be satisfactory. Bearing in mind the principles of law laid down in the above decisions, we shall now proceed with the respective transports which the appellants were assailing. So far as the house is concerned, it is not in dispute that the insolvent has transferred it to his wife, the second respondent, in consideration of the default dower of 5 acres of gold value at Z1,000. The second respondent had produced a deed of marriage, date the 12th April 1952, by which the insolvent undertook to transfer his house if the default dower was not paid within 3 years of the execution of the deed, which is a queer provision inasmuch as the house was admittedly worth more than Z2,000. It is true that Section 53 does not require a transfer to be for full and adequate consideration, but if the consideration is found to be grossly inadequate, it will be a strong evidence of one of good faith and a sufficient ground for setting aside the transfer. Thus, it has been held in MT Maji Donisa BB versus Babu Puran Chandarai, official receiver, and another 11 that Section 53 does not demand that the transfer should be for full and adequate consideration. Hence, the transfer cannot be held to be without valuable consideration unless it is found that the consideration was so small as to be negligible in relation to the value of the property. An inadequate consideration may be evidence of one of good faith, which may by itself be sufficient for setting aside the transfer. In the instant case, the house in question is worth not less than Z2,000 in view of the testimony of Charlie Ansari, a witness cited by the insolvent himself. The receiver had in fact reported to the court that the building worth Z6,000. This house has been transferred by the insolvent to his wife, who is entirely dependent upon him, in consideration of the dower of 5 acres of gold value at Z1,000. It is apparent therefrom that the consideration is grossly inadequate. Moreover, the insolvent had since then been living in the same house after the transfer, which would go to show that the transfer was not bona fide, but made with intent to defraud the creditors. Then we come to the transfer of the tailoring shop to the first respondent, FAIZAR RAHMAN CHOWDHURY. The transfer was alleged to have been made for a consideration of Z5,000, which was made of an old debt of Z3,000 and a cash sum of Z2,000. The first respondent, FAIZAR RAHMAN CHOWDHURY, was unable to tender any satisfactory proof that the insolvent had at any time owed him Z3,000, which is quite a substantial amount. Not a single document was produced to substantiate his allegation that the insolvent borrowed that amount from him or that the insolvent had purchased goods of that value on credit. Then there is his admission that he was aware of the embarrassing circumstances of the insolvent against whom the appellants had instituted various suits at the time when the transfer of the tailoring shop was made in his favor. No doubt a bona fide transfer on account of pressure exerted by a creditor for the satisfaction of his debt in the absence of any suggestion of collusion and without any knowledge of the embarrassing circumstances of the debtor is not fraudulent within the meaning of Section 53, but in the present case, the transferee and the insolvent were admittedly intimate friends. The transferee knew that many suits were pending against the transferor and that he was in embarrassing circumstances at the relevant time of the transfer. All these factors go to show that the transfer of the tailoring shop was collusive and not in good faith, and it should accordingly be avoided. In this connection, it will be of interest to refer to the decision in Official Assignee Madras vs. S.M. Sheikh Moeddin, Ruther 12, where it was remarked that absence of good faith could be proved by showing that the transaction was a sham one, or that there was a residing trust in favor of the insolvent, but the same could be proved by other circumstances also. If an insolvent transfers in favor of one of his creditors to whom he owes much more than the debt due to the transferees, and the transferee also being fully aware of all the above circumstances, and in concert with the insolvent brings into existence such a transfer deed and antedates the same and takes such sealed deed for debt due to him without any contemporaneous advance or other promise to help the insolvent to carry on his business, then the transaction cannot be said to have been entered into in good faith, and the same should be held to be void against the official assignee under Section 55 of the Act. As regards the cargo boat, the insolvent had admittedly paid the purchase price of Jet 15,000 as the guardian of his minor son, Shah Jahan, who was only 9 years of age at the time of the purchase, and is dependent and living with him up to the present day. The insolvent had applied for the renewal of the license of the vessel and had collected hiring charges from the petty traders who had used the boat. Video Exhibit numbered 16 and 17, and the evidence of Mounton Aungjo, creditors witness number 2, although the insolvent and his wife, the second respondent, would have it that the boat was purchased with the money belonging to the grandmother of the minor. The grandmother had not come forward and explained how and from where the money had been acquired. In fact, according to Exhibit Salon, which is a copy of the statement of the insolvent himself, the grandmother is actually living with and dependent upon him, which clearly indicates that the version cited by the insolvent and his wife is far from the truth. It is therefore evident that the insolvent has purchased the vessel Binami in the name of his minor son, with the object of evading the rightful claims of the creditors. In the result, the appeal succeeds, and the order of the lower court is hereby set aside, and the appellant applications under Section 4 and 53 Burma Insolvency Act are, along with costs in both the cost, advocate fee, debt, 85,